A, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
All right, good morning, and welcome to today's sitting of the Appeals Court. My name is Ariane Vuono, and I'm joined today by Justice Catherine Hand and Justice Christopher Hodgens. We have 5 cases on today, and we plan to go straight through without a break. I see people who have been here before, so you already know the appellate rules that apply to your argument, but I'll repeat them anyway. You each have 15 minutes to present your argument. You can be assured that the panel has read everything that you have submitted to us, or just about everything, and so we're ready to get right into the meat of your arguments. There is no rebuttal in the appeals court in Massachusetts, and I see that we're ready. Counsel for the first case is already ready. Just let me call it officially for the record. That's okay. 2022-0386, Commonwealth versus Mandy Perry. Counselor.
Good morning. Elizabeth Doherty, appearing on behalf of the defendant, Mandy Perry. In this case, the decedent was verbally confronted by the co-defendant, in this case, Scott Rodericks, the boyfriend of Ms. Perry, who then, out of the blue, sucker punched the decedent, who was intoxicated, as the evidence would show, fell backward and hit the pavement, never waking up, and died several days later. Mandy Perry was jointly tried with her boyfriend, the co-defendant, for first-degree murder. She was convicted of involuntary manslaughter. He was convicted of second-degree manslaughter. This case presents a somewhat thorny issue as to determining Ms. Perry's knowledge of the likelihood of substantial harm and the degree to which she could ascertain the likelihood not from her own conduct, but from someone else's conduct. How likely was it that substantial harm necessary for involuntary manslaughter by wanton and willful conduct would result as a result of someone else's conduct?
Well, couldn't the jury base that on what Ms. Perry would have observed? I mean, she would have observed the cold punch or the sucker punch, as you called it, and that the person was on the ground and not conscious, right?
So the evidence would show that the one witness who perceived the entire incident, Susan Hart, saw one person come out of a driveway. That would have been inferably the co-defendant. Then the decedent come out of a driveway. The co-defendant and the co-defendant proceeded to yell at the decedent, and Ms. Perry ran up beside him, and the testimony of Ms. Hart was just that all of a sudden he just hauled off and hit him, and the decedent fell back, presumably knocked out, and hit the pavement. The evidence would be that Ms. Perry had no notice of that came out of the blue, that it was, as I say, was a sucker punch, and that she would not have had knowledge based on what she observed at that point to know that substantial harm would have resulted as a result of someone else's actions.
Was there not evidence, though, of ongoing kicking by the co-defendant and then of Ms. Perry's involvement in that as well?
So I was looking at this yesterday. The kicking, again, that evidence comes from Karen Waring's testimony, which is more problematic. But sort of stepping back, there was evidence at trial from Susan Hart that the decedent hit the ground, and the co-defendant, the evidence would show, continued to hit him. At that point, the evidence was that Ms. Perry was saying, no, stop. He did not stop. And so I would say that the evidence does not support that she was a willing participant at that point.
Well, wasn't she saying similar words that Rodriguez was saying, like, don't F with us and that sort of thing?
Yes, when she came up, there was evidence that she said that once, but that's not indicative of, it's not a threat. It's more sort of, you know, boundaries or whatever. He was also saying that. I would suggest that her saying that does not state that she was a participant, that she agreed with that, but also it doesn't state that she had noticed that her boyfriend was going to haul off and hit this fellow.
But she did kick him in the head, right?
The evidence was, and again, this comes from Susan Hart's testimony, that as she was leaving, she gave him, and her testimony is to quote, just a little swift kick. I would point out that the evidence is undisputed that Ms. Perry was wearing either flip-flops or sandals. And so that, you know, that certainly was not suggestive of her desire to be in that enterprise.
Why is it that you're concentrating on whether or not there was notice on what the co-defendant was going to do?
Because she needs to, the cases are, and I cited to Commonwealth versus Albarod, that if the co-venturer, I would suggest that there isn't evidence sufficient for there to be co-venture in this enterprise. If the co-venturer is surprised by the actions of the co-defendant, they can't be held liable. I mean, again, this is not, you know, you look at a number of the cases.
Even if there was no notice of the very first punch, certainly from that point on, she would have had her own ability to observe what was happening.
At that point, the evidence was that she was entreating Mr. Rodriguez to stop doing this. And in fact, the evidence was also...
Well, there was that, but there was also other evidence that she was still yelling and that she allegedly gave him a kick.
I'm not sure that that's, to be fair, I don't think that is the case. I think that you know, she ran up and there was evidence that she yelled, you know, don't F with us, don't F with me, or whatever. But when he was hitting him, she was entreating him to stop, that's enough, stop. There's evidence, that's evidence from Susan Hart. There's also evidence that as she was leaving, she said, you know, she pulled Mr. Rodriguez away and said, you know, why did you do him like that, or some word to that effect.
Okay, I asked the question because my understanding of the law is that the evidence needs to show that the defendant intended, in this case your client, to join in the beating, and it did so in a manner that was reckless, or, you know, showed a high degree of risk that the decedent would suffer substantial harm. And I don't see that as necessarily requiring notice of what was going to happen before the very first blow is struck.
Well, as I say, I think it speaks to surprise, and surprise sort of speaks to agreement. And I think the evidence...
Answered my question. I see where you're headed.
I think that the evidence of agreement is not here.
Okay.
You looked as if you were going to ask a question. Okay, I'm sorry.
Thank you.
I'll ask you a question. Now, would you agree with this, that the intent required by the defendant is actually an intent to engage in the reckless conduct and not an intent to bring about the harm?
Yes.
You would agree with that?
I agree with that. And I'm going to sort of step to the side just and sort of acknowledge my own sort of, not confusion or whatever. When you have a joint venturer who is and we don't look at principal or accomplice anymore, but the joint venturer who is the prime actor, and that person is convicted of one crime, and the other person is convicted of another. It's again, as I say, it's thorny for them to be joining in the same intent. But getting back to your question about the conduct. I think it is the conduct, and she had no control over the conduct that resulted in this substantial harm, the standard of harm for willful and wanton conduct that for involuntary manslaughter. She had no control over that. And that's where, again, as I get into...
But you seem very focused on the concept of joint venture here, but the jury was not precluded from finding her responsible as a principal, right?
They were not. They did not.
They were not precluded from doing that.
I was going to say they did not find her...
And what makes you say that? There was no verdict slip that said they found her responsible as a joint venturer, was there?
There were not separate verdicts, but the case was tried on the theory of joint venture, and I think I quoted in the reply brief, the case was argued to the jury. Her liability was joint venture. None of the argument and none of the way that the case was tried would have supported any...
Sure, which makes sense if both are charged with murder. That makes sense that that would be how it's argued, but the jury could still find someone responsible as a principal for a lesser crime, as happened here, right?
Yes, I suppose they could. Again, as I say, I don't think that that was supported with the way, again, the way the case was tried at trial, the way that it was argued to the jury. I would also submit that both theories of, or not submit, but I would point out that both theories of involuntary manslaughter were presented to the jury, both intentional by battery and intentional willful and wanton conduct, and they did not find guilty on part of battery, which again, as I say, that would tend to support that. So, but again, I agree that it is based on the conduct, but it was not her conduct that she had control of. And I think that the evidence was that she attempted to the best that she could. There's a size differential between both of them. I don't know that this was the jury would have seen that she's quite a small woman. She would not have been able to prevent her boyfriend from engaging in this harm. I think that if there aren't any other questions on this, I would like to move on to the error with respect to the prior consistent statement. Okay. The judge permitted, so I think as I alluded to before, the testimony of Karen Waring was very, there were a number of inconsistencies that took place in her, and those were called to attention during cross-examination. The judge permitted the Commonwealth to pump up her testimony to the detriment of my client by introducing grand jury evidence. The judge did not in any way find that there was a contrivance or anything of that nature. In fact, found that it was just inconsistencies that took place.
Didn't the defense argue specifically that this was a lie, that this was recent contrivance in that way? Weren't those questions directed at the witness in that frame?
The witness was challenged significantly with other, and was, at one point was told that there was a lie. The judge did not think, I would submit that the judge needs to find that there was a contrivance, and the judge found that there was not. I think that the Commonwealth argues that it's implicit from the record, and I would suggest that it's not at all.
Well, let me ask you this. If your focus has been on this prior consistent statement, but if someone is cross-examined about prior statements, and as here, the witness admits, yeah, I didn't mention kicking before in my prior testimony, and in the excerpt that is read to her from the police report, she says the same thing. Yeah, I didn't mention any kicking in that. Doesn't the other party have the opportunity to address that same issue on redirect? To just, all right, the counsel asked you about your prior statement. Let's talk about that, right?
Certainly they do, but they didn't do that. They introduced statements, they introduced transcript and page and line of her grand jury testimony. and were able to pump it up that way. Certainly they can try to address that, but they did more than that. They introduced her prior consistent statement, which was...
It was read, right? It was read, her prior statements were read, and she would just affirm, well, didn't you say so-and-so? Didn't you say there was a kicking? Yes, I did. So in other words, the document, when you say the grand jury testimony, that wasn't handed over to the...
It wasn't handed over, but they
Right.
referred to it, they read from
Sure.
the transcript or whatever, which I would
And
argue...
isn't that appropriate on redirect?
No, I don't think so. I think that prior consistent statements they are sought to be, they are generally inadmissible. And unless certain conditions are met, and they were not met in this instance.
Okay, so just so I understand your position, so you're saying that if counsel on cross-examination refers to a prior statement or prior testimony, opposing counsel can't address that same issue to clear up the testimony of the witness?
Not by introducing it in the way that they did. Didn't you testify at the grand jury and then read her statement in there, giving her additional credibility to which she wasn't entitled?
Well, your time is up, but I have to ask, how would this be introduced then?
The judge would have made her, as is set forth in the Mass Rules of Evidence, the judge would have made a finding of that, and that there was a contrivance. She would have
so
made a preliminary finding, which again, as I would point out, as I did in the reply brief, this makes appellate review much simpler unless it's just you just have to sort of look through the transcript.
Well, we always look at the transcript, so that's not necessarily an obstacle, but
Yes, but you
I
don't
see your
really know,
point.
you don't know what the judge's
And
thoughts are.
I've taken you over your time. I'm just going to check with the panel to see if there's any additional questions, and there are not. So thank you very much.
Thank you very much.
Good morning. Thank you. May it please the court, Stephen Nadeau on behalf of the Commonwealth. Beginning with the sufficiency argument, I would suggest the evidence in this case was sufficient to find the defendant guilty of involuntary manslaughter by wanton and reckless conduct, both as principal and as to joint venture liability. In a case like this, where the evidence shows that the defendant joined in a joint beating or participated in a joint beating of the victim, in this case, the sort of evidence of principal and joint venture doesn't exactly merge, but it kind of effectively overlaps. And certainly there's no suggestion of a prior conspiracy to beat or kill the victim in this case, but I think the significant evidence is what follows after that initial sucker punch. The victim hits the ground, cracks the back of his head. Certainly that's serious enough for Mrs. Hart across the street to realize, hey, he's out, as she screams at them when she comes out at some point. But the defendant, by contrast, joins in the beating. She joins in screaming, "Don't mess with us," while he's on the ground, as she kicks him, according to Ms. Waring, a few times, and according to Ms. Hart, at least once in the head. And granted, there are some statements from the same witnesses that she was also like, hey, stop, you shouldn't have done them like that, but I would argue that that speaks to her recognition of how serious these circumstances were, but nonetheless her conduct in the face of that recognition.
Now, I don't remember reading in the transcript that she said stop, because that would be kind of a significant point. Do you know where that is in the transcript?
That may have been at a prior hearing, kind of, that she was trying to pull him away from the thing, but I think you shouldn't have done him like that. It may have been the statement that came in at trial. But be that as it may, I think that all goes, again, to her recognition of how serious the circumstances were, including the consciousness of guilt evidence, that she's the one who kind of, hey, let's get out of here. Once the police are on scene, she sort of joins in the fiction that it was someone else, or they were the ones that found him and were trying to summon help. And so all those facts together, again, suffice to establish guilt. As to the prior consistent statements, while the trial judge did not make an explicit finding as to recent contrivance, I think that was probably unnecessary. On this record, during the cross-examination of Ms. Waring, that was essentially the theme of the defendant's cross-examination. That's a lie that you saw my client kicking. Didn't the prosecutor tell you, perhaps in a conversation last Friday or within the last week, that they needed this testimony from you to secure a conviction? Are you sure they didn't tell you that? Are you absolutely sure? Clearly then, at least a claim of recent contrivance. And it's sort of after the initial, Ms. Waring's testimony was split over 2 days, kind of after the cross-examination gets going on that first day, Judge Dupuis kind of is already like, hey, they're going to be able to go through her prior statements based on this, based on a clear claim of recent contrivance.
Well, let me ask you, because the same question I asked counsel, because I noticed the Commonwealth didn't argue this in its brief. You didn't argue this was appropriate for redirect. You just kind of went with the defense argument as far as prior consistent statements. So let me ask you, if you have a witness on the stand and on cross-examination that witness's credibility is damaged because she admits, yeah, geez, I didn't say that in my prior testimony, or no, I guess I didn't say that in my statement to the police, doesn't opposing counsel have the right under redirect to rehabilitate that witness and to ask her specifically about her prior statements and ask her, well, you know, did you actually testify to the kicking at the prior testimony and so forth? And then, yeah, now that you mention it, I did say that. Yes, that's correct. Isn't that appropriate rehabilitation?
I think so in certain circumstances, and if I'm, you know, wrong on this, there's another basis of admissibility for the grand jury statements, that's great, but as I read it and as I noted in the brief, the defendant, for instance, questioned Ms. Waring extensively about her statements during the police interview and at the 2019 motion hearing. And so with allegedly inconsistent statements. And so at that point, the Commonwealth, and as the prosecutor did, was entitled to introduce other statements from the same kind of conversation or hearing to provide fuller context and to sort of rehabilitate the witness. My understanding of prior consistent statements from an unrelated hearing is that there has to be a claim of recent contrivance. But certainly all those other statements, consistent statements that we got in from the police interview and the motion hearing were admissible for the reasons Your Honor describes. And maybe as to the grand jury testimony as well. But regardless, I think they were properly admitted based on the claim of recent contrivance. And even if Judge Dupuis is kind of mistaken about whether there was a claim of recent contrivance and what the foundation should be for admitting them, the foundation, again, is clear on the record. And
what do you say about counsel? She made a good point about the flip-flop. If the defendant is just wearing a flip-flop, can the jury really infer reckless conduct by kicking someone with a flip-flop?
Yes, I think so. Personal weapons, hands, and feet in these kind of circumstances could cause significant harm the way a punch could. I don't think there's any reason a foot needs to have a shoe on it. And depending on the circumstances, you know, it would be highly fact-dependent what kind of harm that could cause. You know, kicking the shins with a bare foot, maybe not, but a kick to the head to a guy who's already suffered a serious injury, it would be a different question, obviously. So I think in this circumstance, the fact that she's wearing flip-flops is not outcome determinative. If there are no questions about the first two issues, I'll kind of go to the closing issue. As we acknowledged, there were two misstatements during the prosecutor's closing argument. One, both drawn from Ms. Hart's grand jury testimony that she testified at trial somewhat differently. As to one, as I know, where she says, see you stupid ass. Kind of the difference there, I think, does not,
Yeah.
the distinction there does not make much of a difference substantively. Obviously,
It's
the
the
second
second one that's a
mistake,
little more problematic.
yes, because I think it, as we acknowledge, speaks to a more malicious state of mind. Or your next is, we'll do the same thing that we've done to the victim to you. But in light of all the circumstances, that was an argument marshaled to convict the defendant of murder. Obviously, the jury rejected that argument, found her guilty only of involuntary manslaughter. So to the extent it bears on intent, they were not overwhelmed by that argument.
Just to be clear, you've described it as a misstatement, and in your brief, you quote from a case to say that it was regrettable, but are you conceding that it was error to have said that statement?
Yes, that was not the...
That's what I thought, but I just wanted to be sure.
Yes, that was not supported by the evidence. But I just note that it was the grand jury, it was how she had testified at the grand jury, just to kind of show that the prosecutor was not engaging in bad faith to sort of pump up the evidence. But that aside, the judge's instructions that, your memory of the evidence controls, that kind of puts them on notice that you may hear things in this argument that you do not recall, that the witnesses said or that the evidence supported. It is your memory that controls. The fact that there was no objection to this particular misstatement, while both attorneys objected to several misstatements, suggests that they did not feel that this was something that struck directly to the heart of their case. And in light of all the circumstances, again, it was one minor misstatement cosmetically, but it was troubling for the reasons I acknowledged. But again, in all the circumstances, did not create a substantial risk of miscarriage of justice. If there are no other questions, I'm happy to rest on the brief.
I don't see any. Thank you very much. Thank you both. Your arguments are very helpful, and the briefs were very well done also. We'll take the case under advisement and get back to you as soon as we can. Okay? Thank you. The next case is Kamo versus Michael Minkowski, 2022-0809. Good morning.
Good morning, and may it please the court. Eva Jellison on behalf of Michael Minkowski. I'm going to make a couple broad comments first, and then I'll get into the Sepalonis analysis. Mr. Minkowski was sentenced to a mandatory 10 years in prison because he was 23 and 24 at the time of the offense and 10 years older than the victim. Mm-hmm. And for a typical person, I think the legislature's 10-year gap is probably a pretty good proxy for culpability. It evinces a difference in maturity, probably more predatory behavior. But for Mr. Minkowski, who has fetal alcohol spectrum disorder and attendant developmental delays, it wasn't a good proxy for his culpability, and it probably wasn't a very fair proxy for his culpability. Dr. Kitchener, the expert, opined that Mr. Minkowski's cognitive and social emotional functioning at age 23 and 24 would have been significantly delayed, similar to same-age peers. And what that tells me is that people that functioned like Mr. Minkowski would not have been subject to this mandatory minimum sentence for the same conduct. So moving into the Sepalonis analysis.
Could I just ask one question? Is there something specific about Mr. Minkowski's ability to understand or appreciate the wrongfulness of his conduct that's tied into Dr. Kitchener's opinion?
So I think appreciating the wrongfulness of your conduct is more along the lines of criminal responsibility. Right. And there's certainly there's no argument for me that this was not criminal behavior. I think what I'm talking about more is his moral culpability and what this situation was more like. So if you're looking at something that is perhaps more predatory, less of a peer-to-peer relationship, because a more peer-to-peer relationship, a 17-year-old and a 13-year-old, would also be criminal conduct. but it would be a difference in kind of how we look at that criminal conduct, and that's usually what judges are able to do in sentencing. They're able to look at the specific characteristics of the defendant, and if there wasn't a mandatory minimum in this case, they would have been able to look at Mr. Minkowski's lack of maturity, lack of cognitive abilities, lack of social emotional abilities, and take that into account in the sentencing. And that's really what I think the disproportion is that you can't take into account there is this one-size-fits-all sentence, and it doesn't really apply to someone who has this developmental delay, especially with a statute that's focused on age. You know, this is a very unique statute in the Massachusetts law, and where it's focused on age, and he has a developmental disability, it's really a poor match. And you know,
But you're not saying, for example, that he could not have received this sentence in any event. Let's say there was no mandatory minimum on an age-related situation based on that, and the judge heard all the evidence that you've presented later on to the court, and still decided that the 3 concurrent 10-year sentences would be appropriate. That would really vitiate your argument in a way, wouldn't it?
I think it would be a more difficult argument, yeah. But 10 years for somebody with Mr. Minkowski's abilities in prison was a rather harsh sentence, and was difficult for him. And I think some of the documents that would show that were I filed a motion to file additional documents in the lower court, but to impound them so that, and the motion was never acted on, so those documents aren't in the record. Another option for the court in this case would be to send it back down for an evidentiary hearing and for maybe some review of those documents. I don't think that's necessary.
Let's back up on this. The motion was filed in this court, correct?
This court, no. This is an appeal from a Rule 30A.
Oh, okay. No, the additional documents.
The additional documents. Yeah, no, I didn't file a motion to expand the record.
Okay.
Perhaps
All right.
I should have.
All right. Just
So moving on to the Sapalonis analysis, I think it's helpful that, so the first step is that you look at the offender and the offense, but I think it's helpful, and we've learned from cases like Diachenko and Perez, that the characteristics of the offender can be the sole factor that determines disproportionality, and I think that comes across best in Perez 2, which is the 2018 case, where the offense was certainly very serious, and the sentence would have been appropriate to that offense, but it was not appropriate to Mr. Perez as an offender specifically. And I think something else that we can learn from the Diachenko and Perez line of cases and Luskoff is that development is particularly constitutionally significant in this area of law, and that development affects culpability. So, juveniles are less culpable than adult offenders because they're at a different developmental stage in their lives. Mr. Minkowski was less culpable than perhaps someone else who was a typically developing 23 and 24-year-old person. So I think that those cases can kind of help us do this analysis. It's a very fact-specific analysis. There's no particular test. But, as I stated, I think the assumptions that are baked into this 10-year age difference being the proxy for culpability don't apply to somebody who has these types of developmental disabilities.
What do you mean by being the proxy for culpability?
Well, mandatory minimum sentences, to my mind, they take away the discretion from the trial court to make a determination of the defendant's culpability and what punishment is appropriate to that and what rehabilitation is appropriate to that, and sets it as a one-size-fits-all. So that's what I mean by it.
Okay, all right.
And just looking to some other jurisdictions, this particular sexual offenses committed by people with developmental delays have been found to be disproportionate. Mandatory minimum sentences have been found to be disproportionate. I think the Oregon case is helpful because it's a 6.25 mandatory minimum sentence, and the court found that was disproportionate and that there should have been some sort of more individual assessment of that defendant's abilities and culpability in light of his developmental disabilities.
Can I just ask you about, I think you had mentioned earlier, you said we only have to look as far as the characteristics of the defendant, but don't we also have to look at the nature of the crime and even the impact on the victim? Because we have to keep in mind the victim here is age 13 or under age 13, in that range. So don't we have to take into account the impact that the crime has on someone of that age?
Yeah, it's appropriate to take that into account, but I think that the SJC has been pretty clear in cases like Diachenko and Perez that the characteristics of the offender can be more important in the analysis. And to that point, some other courts have found it persuasive that the type of conduct in this case, which was certainly criminal, but more along the lines of a relationship, was different than maybe some other conduct that could be charged under this that was more predatory, like step-parent acting against a child, or maybe like a trusted coach. And I don't think it's super helpful to make distinctions with a crime like this. It obviously is a very serious crime. So that's why I look to cases like Perez and Diachenko to say that even when there are really serious crimes, sometimes the characteristics of the offender overwhelm that for this analysis. So that would be my response to that.
But even if we accept what you're saying is true, and let's say we put the defendant in the category of a peer, and assumed he was a 13-year-old like his victim, if that were the case, he'd still be responsible for the crime, right?
Absolutely.
And really, both, in a case like that, both the victim and the perpetrator could both be treated as potential defendants, right?
Yes.
So does your argument really get you that far, if that's kind of the state of the law as far as statutory rape goes?
I still think that the argument works because, I mean, if Mr. Minkowski was chronologically closer in age to the victim or the same age as the victim, certainly the conduct would be criminal. But the sentence wouldn't be mandatory, and the judge would have been able to, in their discretion, take into account all of the factors. Perhaps there's a particularly savvy 15-year-old who the judge would feel deserved a more harsh sentence than a developmentally delayed 23-year-old. I don't know, but I think that the fact that the judge couldn't take that into account, that's really the problem here. So it's not that the conduct is any less criminal. It's really in fashioning a sentence, there's disproportion in applying a mandatory minimum sentence and not allowing for that discretion. And I think that that's what some of the cases, that is what the court in Oregon kind of honed in on. It wasn't necessarily, they didn't seem to be as bothered by the number of years, that type of thing, but that it was mandatory and that the court couldn't take into account the defendant's characteristics. So moving on, the next step is to compare the sentence imposed and the punishments prescribed for the commission of more serious crimes in the Commonwealth. I always think it's a pretty fraught exercise to say which crimes are more serious, but I will point out that there are several violent crimes where there is a statutory maximum at 10, like assault and battery on a person over 60, assault and battery on a police officer causing serious injury, assault with intent to murder or maim. Those all have 10-year maximums. And they're certainly very serious violent crimes. And then there are other crimes.
Hard to say they were more serious than something like this.
Like I said, I always have trouble with that, but certainly very serious, perhaps more serious.
That's why we leave it to the legislature, I guess, so that they can debate what's the social mores behind deciding what's more serious and what's not serious.
Certainly, I guess, but the court has asked us to do this analysis, so I guess I will say that those are potentially more serious and certainly very serious crimes that have a 10-year maximum. And then there are lower statutory mandatory minimums for cases where harm comes to children, like deriving support from child prostitution has a 5-year mandatory minimum. Trafficking a person under 18 for sexual servitude has a 5-year mandatory minimum. And rape of a child with force has no mandatory minimum. So I think we could say that there are arguably more serious crimes where people could receive much lower sentences than Mr. Minkowski received.
Can I ask a question? Your brief cites a number of individual cases to support your argument. Are you actually saying that we should be assessing individual sentencing decisions by particular judges, or that we should be assessing the minimum or maximum or lack of any prescribed parameters for the offenses as a whole?
Yeah, the language of Sepalonis would tell me that the analysis is really to what the sentences prescribed by the legislature are, and then those were examples of when the lack of mandatory minimum for rape of a child resulted in less serious sentences. So just more concrete examples of what the legislature prescribed. But the analysis should be to what the legislature prescribed. And then the last step, which is unnecessary if the first two are met, but I think is helpful in this case, is comparing to other jurisdictions. And I think I counted wrong. I think I said 32 states in my brief, but it's actually 33 that allow for less severe sentences in a case like this. And just, as a summary, 16 states have no mandatory minimum, 15 have a lower mandatory minimum, and no higher than 5-year mandatory minimum. And 2 states allow for a bit of a safety valve. Connecticut has a 10-year mandatory minimum, but 8 years can be suspended. Georgia has an ability for the judge in their discretion to depart from a mandatory minimum sentence. So I think that there's certainly many jurisdictions and a majority of jurisdictions where Mr. Minkowski would have been able to receive a more proportionate sentence. And if there are no further questions, I would rest on my brief.
All right, any further questions? I see none.
Thank you.
Thank you.
Good morning. May it please the Court, Hallie White Spate, Assistant District Attorney for Middlesex on behalf of the Commonwealth. The defendant has made a lot of arguments in his motion, in his brief, and up here at argument. But the one argument that has not been made, and the one thing I still have not heard, is any explanation of why the judge below or this court has any authority to alter a mandatory minimum sentence, or any explanation of why Commonwealth v. Lalta Prasad and Commonwealth v. Rossetti don't control this case. The SJC has been clear that where the legislature has set a mandatory minimum sentence, a judge is bound by it. They have no authority to depart downward. And this is why a case from another state, where apparently there are states where that's possible, is not applicable here.
Well, that's not necessarily true in all cases, is it? I mean,
Yes.
if it,
Where there's a mandatory minimum. That's what Lalta Prasad says.
well, actually, in that case, the SJC specifically said that they were not addressing the constitutional issue. All they addressed was whether or not the judge could do, as she attempted to do, was to impose a sentence under the mandatory minimum based on certain factors. But what was not argued in that case, and what is argued here, is that this is a constitutional issue, that as applied here, the minimum mandatory is unconstitutional. And I don't know of any case that says that we cannot look at a sentence where the allegation is that it's unconstitutional and unlawful, not an illegal sentence. It's not illegal, but is it constitutional?
Assuming that's possible, and I keep getting stuck on how a legislative an act that specifically does not permit a court to consider individual characteristics of the offender.
Well, if the statute is not constitutional, then we strike it down,
But
period.
that's a facial challenge. That's not an as-applied challenge. And this is why all the appeals to Dyachenko and Perez and the other, the juvenile life without parole cases doesn't help us, because what concerned the SJC in those cases was not the individual characteristics of the offenders, it was the fact that they were juveniles. Minkowski is not a juvenile. He was not a juvenile when he committed these offenses. And so the argument is that he was
Isn't the argument by analogy?
a juvenile.
Well, there's evidence. Let's just assume for a moment that, credible evidence. I'm not going to, let's assume for a moment, just follow through with my question, that there's credible evidence that this individual was intellectually, cognitively impaired, such that he was more of a peer to the victim in this case, all right? So that can be a group of people, so to speak, analogous to the group of juveniles that the SJC was concerned about in the cases that you just mentioned.
I think that has to amount to a blanket finding that as to a group of people, and however it's defined, a particular punishment is cruel and unusual. This court doesn't have the authority to do that. This court is bound by Lalta Prasad, it's bound by Rossetti, it's bound
Again,
by
but
the
Lalta Prasad
legislature's determination that this is appropriate.
Doesn't say that. They did not address it, the constitutional.
Okay, let's
Issue.
assume that there are circumstances where a 10-year mandatory minimum is, and again, we are not talking about, my sister keeps saying it's disproportionate. That's not the standard. It must be so disproportionate, and this is Commonwealth v. LaPlante, so disproportionate to the offense as to shock the conscience and offend fundamental notions of human dignity. Maybe there are circumstances where an individual offender's characteristics would meet that standard in a case like this. That being the case, one wonders why no one's conscience was shocked at the time of sentencing or at the time of trial. The deficits and challenges that the defendant has were present at that time. They were present from birth, according to the defense. They were present in utero, according to the defense. And yet, there was no, I think that would be an issue better addressed to questions of criminal responsibility than to sentencing once the offense that the legislature has defined and that the legislature has sent the punishment for has been determined.
You had mentioned that this court doesn't have the authority to decide this constitutional issue. Did you argue that in the Commonwealth's brief?
I think I did. I mean, I have said that this court is not empowered to overturn SJC precedents. And I think the SJC has been pretty clear that a punishment that the legislature has specifically said is not to take into account the personal characteristics of the defendant can't take into account the personal characteristics of the defendant. I mean, this court could grudgingly affirm and hope that the SJC takes it on FAR. But I also note that the SJC did not take this case on direct appellate review.
Right. So are you saying that we, as an intermediary appellate court, don't have the authority, and the SJC does? I just want to be sure that I understand the nuances of your argument.
I don't think you do. I don't think you do, because there is no SJC precedent for this. Be that as it may.
Your argument is not that a court, let's just say the SJC, couldn't strike down a minimum mandatory as unconstitutional.
I think they could, but
So I think I slightly misunderstood your argument before. So your point is that we can't, given our role, but it's not that a court cannot.
I think that's correct. I don't want to tell you your business.
Oh no, we know Kamo. We know Kamo versus Doobie. We know our limits. That's not a problem. But I just wanted to make sure I understood your argument, which
This does bring me back to the really fundamental issue here, which is that it is the province of the legislature to set punishments, and there could theoretically be a case, an individual case, where the individual characteristics and circumstances of the defendant were such that punishment prescribed by the legislature shocks the conscience, is so disproportionate that it shocks the conscience and it offends fundamental notions of human dignity. But notwithstanding my sister's attempts to paint this as a romance story of two damaged people finding each other, this was a 23 and 24-year-old man. Whatever challenges and deficits he had, he preyed on a 13-year-old girl who was not just any 13-year-old. She was a 13-year-old who lived with her single mother, who was battling her own substance use issues, gained her confidence, befriended her, and induced her to have sex with him, and then used a whole battery of psychological manipulation to get her to send him nude pictures of herself. And frankly, that shocks my conscience. And I don't think 10 years is a disproportionate sentence, no matter how childlike the defendant now wants to say that he is. If there are no further questions, I'll rely on my brief and ask you to affirm the judgment. Thank you.
Thank you both very much.
I'm sorry. Oh, I was going to hand that to you, and then I forgot. Don't worry about it. It's fine. Thanks.
All right, the next case is Kamo versus Demetrius Goshen, 2022-0237.
Good morning.
Good morning.
May it please the court, Dennis Toomey on behalf of Demetrius Goshen. We're here asking you to please reverse Goshen's manslaughter conviction. We're also asking you to please dismiss the Commonwealth's cross appeal or affirm the lower court order which granted Mr. Goshen a new sentencing hearing. There's serious doubt about whether the jury may have acquitted Goshen but for the numerous constitutional errors at trial and ineffective assistance at trial, and there's a reasonable probability that Goshen's sentence would have been lower had trial counsel provided effective assistance at sentencing. Starting with the new sentencing hearing, there's 5 reasons why you should affirm. First, the Commonwealth's cross-appeal brief was untimely, and the Commonwealth has not established good cause for that delay. Second, the Commonwealth's brief, the cross-appeal brief, does not actually raise an appellate issue regarding the ground upon which the motion judge granted a new sentencing hearing. That is very surprising, but it's also a waiver. The Commonwealth has not argued in its brief that trial counsel provided effective assistance at sentencing. The Commonwealth has not appealed the motion judge's finding on that ground. The Commonwealth has not argued that any findings were clearly erroneous or that the judge erred in concluding that trial counsel provided ineffective assistance by failing to produce and argue available mitigation evidence at sentencing. So because the Commonwealth has waived that issue, I believe this court should and must affirm. But the third reason you should affirm is the motion judge did not abuse his discretion in granting a new sentencing hearing. The motion judge heard live testimony at the evidentiary hearing. He considered the relevant factors. He made correct factual findings, and his decision falls within the range of reasonable alternatives. It's undisputed in this case that trial counsel failed to investigate mitigation evidence and failed to present it. And the motion judge correctly found that that evidence likely would have resulted in a lower sentence. So because the motion judge did not abuse his discretion, this court should affirm.
Didn't the issue of the defendant's age come up at sentencing?
Yes, trial counsel mentioned once that Goshen was 18.
And he submitted some letters in support as well?
He did.
Were those letters part of the record in this case?
No, they were lost by the lower court. There was no copy maintained. But you can see from the sentencing judge's comments at sentencing that it was a family support letter that talked about how Goshen had an absent father and a mother with mental health or drug addiction issues.
And on that point, didn't the judge actually expressly reject the argument in mitigation? He actually said, I think that your client was fortunate. He had a family that tried to provide support. He didn't take advantage of it. And they seemed to blame that dangerous group of kids he got involved with. It turns out that he was the dangerous one. I think that what this shows is that people have been making excuses for your client because he was raised without a father and his mother had a drug addiction. I think if I accede to their wishes and impose some lesser sentence, it would just enable him further. So the trial judge seems to have taken into account these mitigating factors, and then we have another judge who wasn't the trial judge, comes into the case, and he takes a different view. Does that seem correct?
No. Those mitigating factors the judge considered were Goshen's horrific family circumstances. The trial judge did not consider adolescent brain research as a mitigating factor. There was no mention of it in the quote that you just stated, and there was no mention of it at all at sentencing.
But he did consider his youth, and in fact, that's something that's considered all the time in our courts, isn't it? That it's accepted that young people make improvident decisions, and that's taken into account in sentencing every day, isn't it?
it should have been considered. The advisory sentencing guidelines say that youth is a mitigating factor, but here the motion judge, the trial judge at the end of that quote says there were 0 mitigating factors present here. And we know that's not true because youth is a mitigating factor.
Well, he just rejected it. He considered it, but he rejected it.
Well, if he did consider age in his own mind, that's not on the record, but that's not the same as adolescent brain research.
Sure, I understand what you're saying about that, okay.
So I do think there's a difference. Even if the trial judge did say, I want to sentence this 18-year-old, what the motion judge correctly found was that adolescent brain research would have been mitigating, would have explained to the trial judge. The trial judge said this was a senseless incident. I can't make sense of it. The adolescent brain science, which was not challenged by the Commonwealth, in connection with the facts of this case and the prior violence of the alleged victim, that would have made sense of it. That mitigation likely would have resulted in Goshen receiving something less than the maximum. So I think that's the issue. I think that's what trial counsel failed, admittedly, to do here. And so that's why the motion judge did not abuse his discretion. Again, 18-year-olds, the science has shown, and the testimony here proved, they're not mature adults. They're more impulsive in emotional hot cognition situations. They have less ability to self-regulate. They're more likely to misread social cues and be influenced by their peers, like in this case when Goshen was the youngest of 3 adolescents. And most importantly, they're more amenable to rehabilitation and behavior change than a mature adult. And for all those reasons, the motion judge correctly granted a new sentencing hearing in this case. The fourth reason you should affirm, though, is one that was not specifically addressed by the motion judge but was raised, which was trial counsel also failed to present mitigation evidence regarding the alleged victim's prior violence and threats, which provides necessary context. So trial counsel did not ever inform the trial judge that this alleged victim, Borges, before this incident, he became very angry with Goshen and his friends. Borges threatened to kill Goshen and his friends. Borges went to the night school and stabbed one of Goshen's friends. Borges' brother slashed the tires of Goshen's mother's car. And then Borges goes into the Cumberland Farm store where this incident occurred, starts a fight, and puts Goshen's friend in a headlock. And that is the moment in time when you'll see on the surveillance video that Goshen runs over to help. So there was a mitigation argument there as well, that this was not just a senseless killing. Goshen was not out there looking for people to stab. He was in the store to buy snacks when this dangerous man who had stabbed his friend previously came in and started a fight. And that was another ground of available mitigation that trial counsel should have argued at sentencing, and that, I believe, would have made a big difference as well. The fifth and final reason you should affirm, and this dovetails beautifully with the case you just heard, is we're arguing that you should extend the Perez case to 18-year-old offenders. And this is the only of those 5 reasons that's admittedly requires a little bit of heavy lifting. The other 4, I think, are very clear from the record and from the things that the Commonwealth has waived. But based on adolescent brain research, 18-year-old offenders are not the same as mature adults. They're not psychosocially or neurobiologically developed yet. And so for the same reasons in the Perez case for juveniles, these 18-year-old offenders are much more amenable to rehabilitation. And that makes the sentence arguably disproportionate because an 18-year-old, Goshen here got an 18 to 20-year sentence for manslaughter. If he or an adult had been convicted of second-degree murder, which is clearly a more serious crime, he would have been parole eligible possibly at 15 years. Now it makes no logical sense, but we're making a constitutional claim here that this court, based on Article 26, the Perez line of cases, the adolescent brain research we presented here, as well as the pending Mattis-Robinson cases in the SJC, and Judge Ullman's finding in Suffolk Superior Court. All of that combined, we respectfully urge this court to extend Perez to Goshen and 18-year-old offenders. And this is an issue that I think will have some bearing and give some guidance if there is a new sentencing hearing in this case as to what the maximum or minimum should be. Turning now to the trial errors, we're asking you to reverse Goshen's conviction. There's numerous cumulative errors at trial, as well as ineffective assistance at trial, that combined, we can't say that the jury still would have convicted Goshen of manslaughter. If the jury had heard from the expert pathologist who testified at the evidentiary hearing, who said that Goshen could not forensically have made all 8 stab wounds. So that means one of the other kids committed at least some of the stab wounds. which is relevant to the issue of causation, and it raises a lot of reasonable doubt.
Well, was the testimony that it was not possible forensically that one knife could have made all those stab wounds, or was it more concentrated on, given the time frame, one person could not have actually stabbed somebody 8 times in that short time frame?
Sure. So there were two issues. The first was that based on the anatomical locations of the body and the time frame where Goshen on the video is involved for only 2 seconds, he could not have possibly made those 8 stab wounds on different locations of the body. That's one issue. But the pathologist also testified that we don't know which knife could have made the stab wounds. Any one of those knives recovered could have made any one of the wounds. And the missing 4th knife, which the cooperating co-defendant Hairston, he ditched and hid and was never found. That knife obviously was never tested, so that knife could have caused some of the wounds, including the fatal wound as well. So the jury never heard that testimony, and the trial prosecutor argued the opposite in closing. Not based on any evidence, but she argued that only the blue-handled knife could have made all the stab wounds, and she argued that Goshen made all the stab wounds. That's not true, but more importantly, it wasn't supported by the trial evidence. So if the jury had heard...
Well, there was evidence that there wasn't any blood, that there was forensic testing on 3 knives, right?
Yes.
Okay. 2 of them that showed that there was likely not used, and 1 that was used, which is the one that your client was wielding.
Well, 2 of them had no substances on it when they were tested, so we don't know if they just weren't
So in
used
other
or
words,
they
the
were wiped
prosecutor's
down.
comment was not out of bounds in terms of what the evidence showed.
I don't think anyone can truthfully say that Goshen committed all 8 stab wounds in this case. Have you looked at the surveillance video?
Yeah.
You have? There's no way. Respectfully, there's no way. The cooperating co-defendants were not truthful. But that brings me to the second of the cumulative issues, the unredacted cooperation agreements. The trial judge clearly erred, and the Commonwealth conceded this error, in refusing to redact the cooperation agreements of the 2 co-defendants who got sweetheart deals. 9 times in those agreements that were entered as exhibits, the jury is told about the contingent obligation to tell the truth, and then the attorney's signatures are there, which are also supposed to be redacted. In a case where the only evidence that Goshen committed any stab wounds at all came from the testimony of the cooperating co-defendants, and the only evidence that Goshen handled the blue-handled knife with the biological evidence on it came from those 2 co-defendants. That error, it's a constitutional error, it's preserved, and the Commonwealth has not proved it was harmless beyond a reasonable doubt.
What's the constitutional aspect of that error that you're highlighting?
Impermissible vouching, which trial counsel did raise in his objection at trial. And this is a situation when the jury gets these cooperation agreements in a case where credibility for those kids is everything. It was the whole defense trial theory, was that those kids were lying and that Hairston really stabbed Borges, causing the fatal wound. The jury would likely take those agreements as a sign that the trial prosecutor believed that these kids were telling the truth, and that all the defense lawyers signed off as well, so that everyone thought they were telling the truth. And respectfully, they weren't, but more importantly, that could have influenced the jury verdict, and the Commonwealth cannot prove it was harmless.
Yeah, but the reason for the redaction in the Chiampa case, the reason it says references to truthfulness should be redacted is so as not to mislead the jury into thinking that the Commonwealth knows something that everybody else doesn't know, right?
Yes.
But if you have the judge specifically instruct the jury, you should also consider the fact that the government does not know whether the witness is telling the truth. That's a pretty powerful instruction, and doesn't that dispel any possibility that jurors are going to assume the Commonwealth knows some special information that suggests this witness is being truthful?
Well, I disagree. I think that is a factor that you should consider when deciding whether it was harmless beyond a reasonable doubt. But I would note the judge did not give that Chiampa instruction for one of the co-defendants.
But it was in the final charge, though.
Yes, it was. But that specific, the language of that instruction said was talking about their testimony, not the cooperation agreements. So I do think that the curative instruction was not enough to actually cure the prejudice because the error came in the agreements, because it was repeated 9 times in the agreements, and because of the importance of the co-defendant's alleged credibility in this case. So I'd argue that the curative instruction did not do enough to actually cure the prejudice. Turning to the the inadmissible autopsy photos and the medical examiner, and the police witness testifying that he saw something on the video, a sharp object. You watched the video. I won't ask you now, but just think whether you saw a sharp object in Goshen's hand on the video. The jury would have likely credited the police's testimony.
And on that point, you're exactly right. Wouldn't jurors then, seeing the very same thing, wouldn't they say, he doesn't know what he's talking about? What, doesn't that cut against his credibility, that he's kind of gilding the lily there to say there's a sharp object?
What if they said instead, I didn't see it, but that guy's a police officer?
I mean, you're just saying it's evident that it's really not clear that he's holding a sharp object, so that really suggests that the troopers...
I'm saying there's a risk that the jury could have said, I'm going to trust the trooper even if I don't see it. I can see I'm almost out of time.
Examined on that, though, correct?
Yes,
Pretty
he was.
stringently to
Yes.
raise that in front of the jury?
Yep. I can see I'm almost out of time, but I just want to say this is a perfect panel to issue a published decision in this case that would give guidance to trial prosecutors and appellate prosecutors in future cases. If there are no further questions, I rest on my brief.
Just checking. Thank you.
Thank you.
Thank you very much.
Good morning. If it pleases the court, Arne Hansen for the Commonwealth representing the Plymouth County DA's office. With respect to the defendant's sentence, it is very proportional and appropriate in this case. In fact, the defendant received a gift where he was convicted of manslaughter, where the judge instructed the jury as to the manslaughter elements, where the defendant was not entitled to that. Clearly, the jury found that the defendant stabbed the victim to death where they convicted him of manslaughter, but none of the elements of manslaughter here are present that would have warranted an instruction to the jury on that charge. Specifically, there's no reasonable provocation here. The defendant was not in a position where he lost self-control in the heat of passion. He was never actually engaged. He stepped in as the fourth person in on a 4-on-1 fight that the victim was clearly losing. With regards to sudden combat, again, the victim never actually attacked the defendant in this case. He was the fourth person in, and excessive force in self-defense. Here, the use of the knife was unwarranted, even if he claims that he was coming to the defense of others, which he couldn't because he didn't actually take the stand at trial to explain what he observed and what he thought. This was a fight between unarmed combatants, which escalated when the defendant brought a hunting knife into it. So, where the jury convicted the defendant of stabbing the victim, the appropriate sentence, or the appropriate sentence here, would either be conviction under murder 1 or murder 2, and to be looking at life. So in that respect, the defendant received a gift in this case. With respect to whether or not his sentence is...
Are you saying that we should ignore a constitutional argument regarding a sentencing that's imposed on manslaughter simply because he was not convicted of the greater offense of murder?
I'm saying it's something that the court should consider, and I'm going to go into whether or not the manslaughter conviction was proportionate now, if that works.
I mean, that is the jury's verdict. The jury's verdict is that it was manslaughter.
Correct. I'll defer my argument to the proportionality of it. So when looking at whether or not a sentence is constitutional, we look at the proportionality analysis, which is the nature of the offense, the sentence here versus that what might have been imposed if the defendant was convicted of murder, as well as compared to sentences in other jurisdictions. Here, again, the nature of the offense is the defendant takes advantage of a situation and stabs this victim to death when there was no need to do so. Yes, the victim did start this altercation, but what he did was took a flag out of Garcia's pocket. And then Garcia put him in a headlock, and Hairston jumped in, Fry jumped in, and it was a fist fight. It's of note, the other 3 co-defendants who never stabbed the defendant also had knives on them and never saw the need to actually use those knives because they were beating this kid up. There was no cause for concern there. With respect to the sentence here versus what he would have received in terms of if he had been convicted of murder, the defendant here received 18 to 20. The defendant now argues that he's only parole eligible at 18 years, but that's actually incorrect. If you look at the statute, he can take 35% of his sentence off and become parole eligible at 11.7 years. Now, there are numerous ways for him to get good conduct credits, and when I looked at the statute, it appears that It's easy to go over the 35%, but the statute caps it at 35%. So your good conduct, you could easily get a 50% credit based on your actions while you're incarcerated, but it caps it at 35%. So here he's actually eligible at 11.7 years and not 15 years where he would have been if he had been convicted of murder. So the defendant argument falls flat in that regard because his sentence is not higher than what someone convicted of murder would receive. That is 15, parole eligibility at 15 to life. Here his sentence is capped at 20, but he could be out in 3 years, provided he had enough good conduct credits, but that's, again, determined by his conduct while he's incarcerated.
Did you just say he could be out in, did I hear you say 3 years?
Yes. So it's my understanding that the defendant's been in...
Oh, 3 years from now?
Correct.
Okay, all right.
He's been in custody
I
since
understand,
October of 2014, so he's about 8.5 years in. And then with regards to the sentence in relation to what is imposed in other jurisdictions, I looked at New England only because it shares a similar political mindset as well as cultural mindset. The only state that has a lesser maximum for manslaughter is Vermont. Connecticut, which is 15 years, Connecticut is 20 years, and everything else in New England is 25 or 30 years. So Massachusetts, the sentencing guidelines in Massachusetts are in line with the rest of New England, if not a little bit lower. So I'd certainly argue that given the conduct, his sentence was certainly proportional to his actions, where he interjected himself into a fight. There was no threat against him, and this was a fist fight that turned into a murder because he decided to bring his hunting knife into it. With respect to the defendant's other arguments, with regards to the truthfulness portion of the cooperation agreements, yes, that should have been edited out, but it wasn't. But again, the defendant didn't suffer any prejudice here because the Commonwealth did not specifically vouch for the credibility of the witnesses. In the cases where these convictions have been overturned because of the cooperation agreements being entered, the prosecutor states that they have specialized knowledge that the defendant or the witnesses are telling the truth, and they have reason to believe that they are telling the truth. Here, if you look at the prosecutor's closing argument, what you see is prosecutor, yes, relies on the testimony of Hairston and Garcia, but also backs it up with the other testimony which was admitted, including the video, the exhibits, and the testimony from the medical personnel who treated and examined the victim. With regards to the photos that were entered, the ultimate issue here is that cause of death was not in dispute. It's clear that the victim was stabbed to death. And the question before the jury was who did it. There were 3 photos that were admitted through the ER doctor who operated on the victim in that case. The autopsy was done the day after. I would state that the doctor who operated on him certainly was familiar with the victim and could have authenticated those where he operated him on the day before, and what he really testified to was what surgery he did, how he treated the victim, what the victim's injuries were, and then he used those photos to demonstrate, yes, this is the one fatal stab wound in his heart, and this is the fatal stab wound in his abdomen. The other 5 photos were introduced through the substitute medical examiner. That was an error. He should not have been able to do that, but the defendant did not object, and therefore the trial moved on. Had the defendant objected and that objection been allowed, the Commonwealth could have introduced those through Trooper Khalil, who was present at the trial, but the Commonwealth did not call him as a witness. He was on the witness list, and he did attend the autopsy. I introduced, as part of my record, the autopsy sign-in sheet that has his name on it. So certainly those could have come in. But again, the ultimate issue is not cause of death, but who the killer was, and none of this evidence really speaks to that, and none of this implicates this defendant.
Well, except part of the purpose in introducing the photos was to show the jury the location of the stab wounds and so forth, and the relative size of the different wounds. So isn't there some force to what the defendant is saying, that these photos did have the potential for some prejudice if the jurors linked up the size of the wounds with the size of the knife that the defendant supposedly had?
Correct. So there were 3 knives recovered in this case. There was evidence that the 2 of them had not been used There was no blood recovered on them, and there was no DNA recovered on them. They didn't have the greasy substance that was consistent with entering a human body on them. So that really only left one weapon, which was the knife that the defendant was wielding. And that weapon was, in fact, large enough to cause those deep wounds that went deep into the internal cavity of the victim. With respect to the defendant's claim that there may have been a fourth knife used by Hairston, yes, that's a possibility, but it's conjecture at this point. The defendant, that Hairston stated that he had a 3-inch knife, he didn't use it and he threw it away. The jury was free to believe him or not believe him. If that knife had been recovered, certainly the landscape of the case may have changed, but again, that's all speculative. Let's say there was blood on that knife and it shows that 2 knives were used. It doesn't prevent this defendant from being convicted as well. It would have likely just led in Hairston's conviction as well. They could have been tried as joint venturers. But again, that's all speculative because that wasn't the information in this case. I'm not sure if that addresses your question. With respect to the testimony of Trooper McDonald, again, this was a lay opinion testimony. What he did was he observed the video. He opined that he saw an object in the defendant's hand right before the defendant engaged with the victim. The jury was certainly free to disbelieve him, and I've cited case law in my brief that supports that notion, where the jury was able to look at the video, go through it, pause it, go through it frame by frame. They're able to decide what they see for themselves. And again, that wasn't the only testimony or evidence that placed the knife in the defendant's hand. There was also the testimony of Hairston, who stated that he saw the defendant with that knife prior to entering the store, and there was the testimony of Garcia, who stated that he saw the defendant holding that knife and stabbed the victim during the fray. With respect to the jury instruction, I would just ask that you look at the jury instructions in general. This occurred during the murder 2 portion of the jury instruction. There was use of a dangerous weapon. The court gave that instruction and then it seemingly started to talk about assault with a dangerous weapon and corrected itself. There was really no prejudice there. In the totality of the circumstances, the instructions were correct. With regards to the ineffective assistance of counsel argument, the expert pathologist, I don't believe that would have really added anything to this case. That individual says the 3 knives recovered, any 3 of them could have been used as the murder weapon, but again, there was no evidence that the other 2
Do you want to get to the sentencing hearing before your time does not run out?
Yes, with respect to the sentencing hearing, I would ask that you reverse the judge's decision. The judge Judge Sullivan relies on Commonwealth v. Watt, which looks at whether or not 18 to 21-year-olds can constitutionally be sentenced to life without a parole without being considered depraved. Again, because the defendant was convicted of manslaughter, whatever happens in that decision with the SJC really has no bearing on this case, because the issue there is very narrow. It's whether or not...
Do you agree, though, that defense counsel did not present evidence that could have been considered mitigating circumstances with respect to sentencing?
Yes, that's fair. But with respect to what may or may not happen with Watt, because this defendant was convicted of manslaughter, it really doesn't matter, because we're talking about parole eligibility after 15 years or none, versus being parole eligible after 11 years in his case. So I don't see how that decision would actually impact this defendant.
Nope, I think that the issue is whether or not, and as Judge Sullivan pointed out in determining that in ordering a new sentencing hearing, is that there was additional evidence that could have been and should have been presented to the trial judge that might have made a difference. And the fact that that did not happen, that defendant deserves to have an opportunity to present that evidence at a new hearing. How did he abuse his discretion in concluding that that was the case?
I would argue that there was additional evidence presented during the course of the trial which would make the 18 to 20-year sentence proportional and appropriate in this case. The judge was allowed to consider hearsay evidence, and there was substantial hearsay evidence discussed during the trial.
Not just the proportion part, but the fact that the trial counsel was allegedly ineffective for not presenting additional evidence at the sentencing hearing.
If I may have a moment. And I would just defer to my brief on that point.
Excuse me, I'm sorry.
I would just defer to my brief on that point.
Did you want to address the argument that your cross appeal should be dismissed?
I would just ask that this court take the issues under advisement on the merits of the case and not because of procedural transgressions. With respect to what may or may not have happened with this case prior to my getting involved, I think ADA Burbine's affidavit that she filed with the court probably explains it better than I did. With respect to my involvement, I would just again ask that you judge this case on the merits and not because of the fact that it may have been filed late. I had 2 SJC briefs due at the beginning of the year, and this was right behind that. I wrote this brief as quickly and as efficiently as possible, and I got it in before the deadline. I wrote it in about 2 weeks, and it took another week to review, and then we got it in on March 2nd when the deadline was March 10th. So after the issues had been addressed, I feel that our office did everything it could to get this in on time.
I may have misunderstood or misheard what you had said in answering the last couple questions, but are you conceding that defense counsel was ineffective in his sentencing argument?
I am not.
You are not?
No, I'm not. I'm sorry if I did not make that clear.
All right.
Okay. I'll see if no further questions from the panel. Thank you both very
Thank you.
much. We appreciate it. That briefs were long but very helpful. Okay, our next case today is Julie Rabinowitz. I'm going to start that one again. Rabinowitz. I'm going to have you help me when you get up here and teach me how to say this name correctly. I apologize. Thank you. And versus Mark Sheckman, 20-22-0378.
Justice Vuono, Justice Hand, and Justice Hodgens, good morning. I am Mark Booker. I am counsel to the appellant, Julie Rabinowitz. Ms. Rabinowitz is here in the courtroom with us this morning. I'm pleased to be with you. I want to point the court to appendix page 232, which contains the trial judge's, a page from the trial judge's findings and rulings, because I believe that the real heart of the issues that you justices have to decide appear there at that page. And there, I won't quote it in its entirety, but there's a paragraph, the first full paragraph begins with, and I'm quoting, "The separation agreement was created in order to effect a divorce and was inextricably linked with the stipulation regarding custody of the children," and the analysis goes on. My principal contention on this appeal is that during the course of the trial, the separation agreement was entered into evidence. The separation agreement contains 14 numbered paragraphs. Those 14 numbered paragraphs deal exclusively with financial matters and with other property-related matters. None of the provisions in the separation agreement deals with custody of the children. None of the provisions in the separation agreement deals with the interpersonal relationship between the parties. Nothing in paragraph 6 of the separation agreement, which contains the requirement that the defendant make the payments that are at issue here. None of that paragraph contains any condition that those payments are conditioned on the conduct between the parties after the separation agreement was ordered on March 17 of 2014. This was a 17-year marriage. The probate and family court at the time that it issued this, issued the separation agreement and declared that the separation agreement would be incorporated but not merged into the judgment and would survive.
So essentially you're saying that the separation, if I understand correctly, the separation agreement should be read really in isolation, not in context of the other issues that were addressed at the same time.
I think that's fair. I don't want to connote anything pejorative about the other orders that the family court made, but I want to stress that the other orders were not in evidence. So these findings by
Didn't the judge actually say that she was going to look at the documents that were generated in the probate and family court case?
I believe that she did.
And was there any objection to that?
I don't know that I voiced an objection to that, but
I didn't see one, but I want to double check with you.
No, but I know at page 44 of the trial transcript during argument, I argued to the trial judge that none of those other documents was in evidence, that the only thing that was in evidence on this score was the separation agreement, and again, that the separation agreement was a document that was of an exclusively financial character, and that the separation agreement fixed the parties' rights and obligations as addressed in the separation agreement, and that the implied covenant of good faith and fair dealing regulates the substance of the contract at issue. Here, the contract at issue is the separation agreement, and the plaintiff, Ms. Rabinowitz, did nothing that breached any of her obligations under the separation agreement. And
Other than what the judge pointed out would be to inhibit Mr. Sheckman from actually performing his duties as a dentist so that the payments could be made.
yes, Your Honor, but there was no evidence at the trial that Mr. Sheckman was actually inhibited in any way. In other words, as I point out in the brief, there was no evidence at the trial that Mr. Sheckman actually could not practice his profession as a consequence of this incident that occurred on August 11 of 2015.
Could that be inferred, given the drama and trauma involved with a situation like this?
I respectfully don't think that you can just make that kind of an inference without any basis. In other words, the incident was described in a very abbreviated form, subject to the trial judge's rulings on the admissibility, concerning that incident itself. But there was no evidence that Mr. Sheckman actually sustained any particular injury. There was no evidence that he ever had to stop practicing, even for 1 second. There was no evidence that he lost any money. There was no evidence that his practice, which is the subject of this property division, by the way, the value was diminished in any way. And that is what the cases on the implied covenant of good faith and fair dealing require. They require that a party they enjoin parties who are parties to a contract from doing anything that would destroy or injure the right of the other party to the fruits of the contract. So the question becomes, in part, what are the fruits of the contract? And here, we contend that the trial judge made an erroneous ruling of law when she read into the contract, and this is at the page that I cited when I began, quote, the basic right Mr. Sheckman enjoyed under the agreements, plural, to simply go on with his life. There was no such right in the separation agreement.
But isn't she, what she's really referring to is the language in the Anthony Pier 4 case where the SJC referred to bad faith as trying to recapture opportunities foregone. And isn't that really the essence of this? So in other words, the particular provisions that you're referring to really aren't what's at issue. What's at issue is we have a contract that's been entered into by two parties, and one of those parties tries to kill one of the other parties. Now, can't you infer from that that is really the ultimate bad faith, that you're trying to recapture a foregone opportunity, that you don't like the deal that you struck, and that's the best way to get out of it. You kill the other party.
Okay. So I have two responses to that. The first is that there's nothing about trying to kill the other party that would actually sweeten the deal for Ms. Rabinowitz. There's nothing about killing Mr. Sheckman that actually would sweeten the deal or enhance her benefits under the separation agreement. That's one. Two is, as I point out in the brief, the plea of guilty to the assault with intent to murder indictment, that guilty plea, which did not come, of course, at the conclusion of a trial where issues were determined by a fact finder, that guilty plea doesn't have preclusive effect. It doesn't have collateral estoppel effect. It doesn't determine definitively that Ms. Rabinowitz actually tried to kill Mr. Sheckman. And the cases I cite are from the Supreme Judicial Court, including Nisolek. And there, in that respect, we also contend that the trial judge made an erroneous ruling of law in giving the guilty plea that kind of preclusive effect.
Well, rather than preclusive, I mean, isn't it appropriate to accept that plea? The plea was given under oath, presumably to facts that establish assault with intent to kill. Why doesn't that establish that that was the case by preponderance of the evidence?
Well, because as the court determined in Nizelek, I'm just going to try to find the portion of it in my brief, Your Honor.
In other words, if there had been perhaps contrary evidence or something like that, and that was ignored or not paid attention to as a result of this plea agreement, we might be, I think your argument might have a little more force, but at face value, so to speak, why doesn't it establish the facts of the indictment?
I will just point, Your Honor, to page 31 of my brief. There's a block citation from Nizelek, and if I may, I'll just read a portion of it. And this is the SJC speaking in Nizelek. And quote, "It is true that before accepting a guilty plea, judges in this Commonwealth must take great pains to ensure that the plea has a basis in fact. Nevertheless, the taking of a guilty plea is not the same as an adjudication on the merits after full trial. While the judge taking the plea must satisfy himself that there is a factual basis for a charge, he need not find the defendant guilty, that the defendant, actually committed the crime to which he is pleading guilty. Furthermore, because there have been no findings, a conviction after a plea of guilty does not present the possibility of inconsistent factual determinations."
I understand that, but
Yes,
I
Judge.
don't know how that really answers my question.
I'm sorry.
No, it's okay. Maybe the quibble's with the SJC and not you. So, in other words, there's nothing. I'm having trouble understanding why it would be erroneous for the judge in this case to look at that plea without any contrary evidence and say, well, it establishes, at least at a minimum, that I can, by preponderance of the evidence, I can, the judge, conclude that this event actually occurred.
Okay, so going back to, I think, a question Your Honor posed earlier, which I think is related to this one, obviously, on the same subject. There actually was no evidence at this trial, the civil trial, that the plea was taken under oath. I'm not going to suggest something frivolous.
Once again, could that be inferred?
I think that it probably can. But more to the point, there was no evidence during this civil trial that the plea judge in the criminal matter actually made any findings. It's clear that a guilty plea was tendered, a guilty plea was accepted, and conviction entered. That's clear, and that's beyond controversy. But beyond that, there was no evidence at this trial, the civil trial, that during the incident underlying the conviction, that Ms. Rabinowitz actually made contact with Mr. Sheckman. And I don't think that you can simply infer that, particularly in the face of this kind of precedent that says that the mere taking of a guilty plea doesn't establish preclusively or conclusively.
Well, certainly, because someone could take a guilty plea in order to spare a victim testimony at trial or because of other family issues, or et cetera. Certainly, that could be the case. But I see your point. You're saying it just does not. You're saying it precludes another interpretation rather than the opposite. So.
Yeah. The other thing is, and I really want to emphasize this, that practically speaking, if the trial judge is right that you can read into a separation agreement that is exclusively financial in its character, terms from other documents or other orders that the Family and Probate Court issued that relate to other matters such as custody of children, and you can take from those documents and read into the separation agreement the right to go on with one's life, then the problem with that, practically speaking, is that it will usher in, predictably, an era in which people will say, litigants in family court will say, well, you were supposed to return the children to me for Christmas, but you held them in Europe on your own vacation, and that didn't allow me to go on with my life, or it interfered with my ability to have custody of the children or visitation with the children, and therefore you are in material breach of the separation agreement, and I don't have to make payments that I'm required to make to you under the separation agreement. Or I posit in the brief.
Well, I guess people could make that argument, but the facts here are somewhat more egregious.
On its face, I can't run away from the obvious. On its face, it's a difficult position to be in to say, after this happened, you had no right to walk away from the agreement. I understand that there is a certain obvious superficial appeal to the defendant's position that if I'm paying you under a contract and then you try to kill me or you plead guilty to trying to kill me, I don't have to pay you anymore. But if you peel back the layer from that superficial appeal, what do we have? We have a 17-year marriage where at the conclusion of the marriage, the family court issues this order, this separation agreement, and looking backward at the contributions the plaintiff made to the marriage during the marital partnership determines that the plaintiff shall be entitled to this money for the contributions that she has made during the course of the marriage. And then after that, there's this, and the defendant begins making the payments as acknowledged in the parties' papers. Then after that, there's this incident, this assaultive incident, however you want to call it. And then the defendant says, aha, I'm excused now. But that's not what the law provides. There are cases in my brief where the family courts have pointed out that tort law exists to address or remedy civil wrongs that people commit against each other. Criminal laws, which obviously are were at play in this circumstance, exist to punish people if they commit crimes. My client was punished in the criminal court for the conduct. But what that doesn't then do is it doesn't then permit Mr. Sheckman to go and say, under this separation agreement, you have interfered with my ability to go on with my life. There's no such right at issue in the separation agreement, or you've interfered with my ability to have custody of the children. There was no evidence of that, and in any event, custody of the children was explicitly not dealt with in the separation agreement. Those issues were bifurcated. And the trial judge, in trying to create this right under the separation agreement, reached out to November of 2013 stipulations and judgments that were never in evidence. And her findings that she documented in her written findings and rulings, to the extent that they rest on those documents that were not in evidence, that the ruling can't stand. In addition to that, she indicated that she was taking judicial notice of the substance of those documents. And again, she based findings on those. The case law is clear. A court cannot do that. A court may take judicial notice of docket entries and papers. I see my time is running short, but it can't
Actually, your time
take
is up.
notice of facts. I'm sorry.
That's all right.
If there's nothing else, I'll sit down.
No,
Thank
no
you.
further questions. Thank you very much.
Good morning, members of the panel. Charles Devine for the defendant, Mark Sheckman. I'd like to begin by just stating some of the foundational facts here before I go into my argument. The evidence at trial was that there were actually 3 documents that made up the relationship between the parties as of the time of the attempted murder. There was a stipulation entered into by the parties in the probate court, which was subsequently reduced to an order. And then about a year later, there was the settlement agreement, which was being performed by Mr. Sheckman at the time of the attempted murder, and it was under that settlement agreement that the payments had ceased. At trial, the testimony was that the husband had custody of the children. The wife, the plaintiff, was unhappy with that agreement. She ended up she ceased contact with the children about 4 months before the attempted murder and had plans in the work for a unification. Although when asked specifically at trial what those plans were, she says, well, I don't really remember. But in any event, she then attempted the murder, and at the time she was being held and the police were on their way, she said, you ruined my unification plans. At trial, the certified record of conviction was submitted into evidence, and then the plaintiff admitted during her direct examination that she pled guilty at trial. So the court did not treat that plea as for collateral estoppel purposes, contrary to the plaintiff's argument. The court treated that as an evidentiary admission consistent with the rule, and it is an evidentiary admission under the Nizilik case that I cited in my brief, and that along with the plaintiff's own admission that she had pled guilty, and during the trial, it was not argued, and there was no testimony from the plaintiff that she didn't attempt to commit the murder. So under the law, all facts that would be relevant to an indictment and conviction of the murder are deemed admitted, and in this case it would be that the plaintiff attempted to murder the defendant with a hatchet. So those 4 facts were admitted into evidence and form sort of the basis of the admission by the plaintiff. So the plaintiff appears to argue in his brief and his oral argument that the attempted murder does not breach the party's contract because there is no term in the contract preventing her from attempting the murder. He says that there has to be a breach of a specific contractual provision in order for the implied covenant of good faith and fair dealing to apply. Well, the defendant asserts that that's inconsistent with the law in Massachusetts. That's inconsistent as to what an implied covenant of good faith and fair dealing is. As you know, every contract in Massachusetts has the implied covenant. It's an additional term to the contract. The plaintiff seems to argue that the implied covenant is sort of a patina that only applies to the express terms of the contract, where the law clearly says it's an additional term. It essentially says that neither party shall do anything that will have the effect of destroying or injuring the rights of the others to receive the fruits of the contract. Now, that language is sort of important.
With that in mind, doesn't there have to be some showing that there actually was some harm to the ability to act on the contract? And what was
So I think that the fact that that language has been repeated time and again by the SJC and the Anthony's Pier 4 case, the Drucker case, that it does not suggest that there has to be an actual physical injury or physical damages. I think that what the case law looks at is whether or not any party did anything that will have the effect of interfering with the fruits of the contract. So in using those terms, I believe that the law is trying to look at the contract from sort of a global or a forest rather than at the tree sort of perspective, just to determine whether the parties are sort of loyal to the relationship that they've entered into because of the contract. And that's consistent with the cases that were cited in my brief.
Let me interrupt you. If there is no consequence, if there is no consequence whatsoever to the other party to the contract, following up on Justice Hand's question, if there is no consequence, then is there a breach?
I think it might be an overstatement to say that there is no consequence here, because there was a battery, there was an attempted murder. The son was present. He was affected by it all.
This is sort of the reverse of the question I asked a counselor, is that, can we infer that, given the circumstances of this drama, that there was a consequence? But there was no direct evidence of a consequence, correct?
There was...
In other words, we do not know whether or not one day of work was changed, or what extent, if any, of the injuries or anything like that.
This is true, and I think that if I think an examination of the record would establish that the court and the parties had eliminated discussions about what evidence would be allowed.
Right, there's the transcript of the pretrial hearing.
And the judge really kept us on a short leash with regard to what evidence we put in about the events and the consequences. She says, I know what happened, because she had been dealing with this now for several years. I know what happened. I see the certified records of conviction. I don't need a lot more information. So I argue that it was important for the defendant's case, because I was unsure of the law relative to the element of intent. I don't believe that intent is a required element of a breach of the implied covenant, but some of the case laws express the fact that intent or motive might be important. So I argued to the judge that I would like to put in some evidence of that, and that's when I asked the plaintiff about her intention, her motive, this plan, reunification plan with the children and all those things. So the court did allow me to go there, but she did keep a tight leash on both parties relative to the factual presentation. So you're right. There was not a lot of evidence on the consequences of the damages that may have flowed from the
I just ask,
attempted
as a
murder.
practical question, apart from the fact that this is a very serious event, why your client didn't go back to the probate court and said, I want to deal with this separation agreement?
Well, I think that certainly that would have been one of his options, although going back to the probate court was not required in this case because this is a separate case that was incorporated but not merged into the judgment.
Right, okay.
So he didn't need to go back to the probate court. It's just enforceable as an ordinary contract. So the plaintiff decided to cease payment. I think the defendant decided to cease payment. The plaintiff went to jail for 3 years. So there was sort of a sizable gap between his not paying and the filing of the claim, which happened upon her release from prison. So, he just stopped paying, and I believe that he thought that because she tried to murder him.
It was an option that wasn't taken in this case.
It was, but I don't know that there was any consciousness about the tactics he would be taking relative to ceasing payment, other than, I'm not going to pay her now, she tried to kill me. I think that's basically what went through his mind. Although there is no evidence of that. There's no evidence of why. That's sort of an aside. But the cases that look at the breach of implied covenant do not require there to be a breach of the contract. So in other words, in the Anthony's case, there wasn't a technical breach of the contract. There was an exercise of a discretionary right. And what Anthony did was absolutely permitted under the contract. The court just held that it was violative of the additional term, that being the implied covenant. And there's 2 cases that I cited dealing with termination of employment at will contracts, the Fortune and the Grand case. And both of those, neither of those involved a breach of the contract, because the employees were entitled under both those situations to fire the employee for no reason or for any reason because it was an employment at will. So the implied covenant doesn't necessarily focus on the act, but it focuses on whether the result is a predictable interference with the reasonable expectations of the parties. And I believe that the trial court was correct in ruling that it was predictable that this act of attempting to murder the husband was the result would have been a denial of the fruits of the contract, which is really what her plans were. I mean, her plans were to gain reunification with the parties, and contrary to what plaintiff's counsel argued, that if she succeeded and got away with it, naturally if she didn't get away with it, none of this would have happened, but if she did kill him and got away with it, she would have been reunified with the children. The money would have followed the children. She would have obtained custody. She would have benefited from the life insurance policy. She also would have benefited from the completion of the settlement agreement. So there was...
I saw that in your brief, but I didn't see where that was, that information about the life insurance policy was testified to at the trial. Did I miss that? Was there any evidence regarding that?
Yes, the settlement agreement was put into evidence.
Oh, I see. It was also it was one of the enumerated paragraphs. That's what you're referring to.
Yes.
Now I understand.
So it was something that was considered by the judge and was argued.
It was in that document. I see. Mm-hmm.
And it was argued both before and after.
Let me ask you about that settlement agreement. So, especially in the context of a probate matter where equity really comes to the fore, if someone comes to court and says that another party has engaged in some inequitable conduct, and as a result of that, the other party wants to get relief from the contract, would you say that the judge would have some authority to change the contract? In other words, instead of just giving your client relief from performance in the entirety, could the judge have said, well, given the circumstances, I'm going to reduce the monthly payment to $1,000 a month for the next 17 months or whatever? Would that be within the judge's power to do that?
So I am not a probate lawyer, civil litigator, and so this is well out of my, away from my wheelhouse. But I think my suspicion, and take everything that I say now with a grain of salt, my suspicion is that because it's an independent contract and that can be enforced or not in any court, I think that the ability of the probate court to modify that agreement is limited. But beyond that, I don't know that there's much more I know about that.
Okay, so you're thinking it's sort of an all-or-nothing proposition. Either your client is relieved from further performance, or he's got to pay.
That is my suspicions, but I could be wrong. But I think that really the important aspect of this case, important aspect of my argument, is the fact that this is a settlement agreement. This is an agreement between spouses having a divorce. And under the Knapp case that's cited in my brief, that these the parties to a settlement agreement have a fiduciary relationship between them, which now takes this implied covenant of good faith and fair dealing and adds steroids to it. It's now the highest duty that the law recognizes between the husband and the wife. So now you not only have the duty of good faith, but you have the fiduciary duty that imposes liability when either spouse simply fails to recognize their fiduciary obligations. And so where does that put us in this case? So if you have, so that puts the wife in the position of protecting the husband from anyone seeking to murder him in this situation. Instead of being the perpetrator, she should have been his protector because she was his fiduciary. She takes the absolute opposite. According to the law, that's what her role would be. Now, being his prospective murderer is an obvious violation of her fiduciary duty as articulated by the Knapp decision, and so we have a clear violation of that duty under the separation agreement. And I think that's what puts this case now into a separate category that's far different from your run-of-the-mill implied covenant cases. So, the fact that the law definitely does not distinguish between the nature of the act but in the scope of things, an attempted murder is well at the end of the scale. So I don't know that there's really any argument here that an attempted murder would somehow not be a violation of that duty. And so therefore, I do believe that this case fits right within the judge's decision that the duty was violated and that it's a material breach, and therefore the plaintiff cannot recover under the contract. Okay. So
your time is actually up, so we'll take that as your
conclusion. I rely on my brief for my other
conclusion as sentence. Thank you both. Thank you very much. Thank you both very much. All right, we're now going to move to our last case of the day. This case is partially impounded. I remind everybody that's partially impounded. Number 2022-0984, NM versus RF. Morning.
Morning. Good morning, Your Honors, and may it please the Court. My name is Brian Waller. I represent the defendant, RF. The plaintiff acknowledges in their brief that the judge made an error of law by his interpretation or failure to apply the statutory factors in finding that these parties were engaged in a substantive dating relationship. Despite that error, there's a question as to when does a substantive dating relationship end? When, or can it ever end? Here, it was 10 years. Does that, and to this judge, even without that statutory factor, did not persuade him that this was not a substantive, or that it was no longer a substantive dating relationship.
Well, does it have to be a current dating relationship?
No, and the statute...
Doesn't say that, right?
Right, and it contemplates that someone can be considered a family or household member based on a prior relationship.
Mm-hmm.
But if 10 years isn't enough, does it have to be 20? There's, and the SJC
Is it fair to say that maybe in some cases, 5 years, and others 8, and others 15, depending on the facts?
Agreed. And that is what the SJC said, that they basically did not want to apply adjectives, I think was the wording, to a statute that was well-defined. And we believe that it should be interpreted broadly. It should be an inclusive statute. But on the facts here, it should not have applied, and the defendant or the plaintiff failed to prove that there was a substantive dating relationship. Even if that argument fails, however, the plaintiff did not
Before you get there, let me ask you this. If that's true, what would you ask us to do with the case if the judge made a mistake and didn't properly consider all the factors in deciding whether or not it was a substantive dating relationship? On that basis alone, what should we do with the case?
So we would ask that it be vacated. I think worst case remanded for a further hearing on that issue. However, despite that issue, I believe that the plaintiff failed to demonstrate that there was any act of abuse. And the statute is clear that in the tense that the verbs are written, that it requires some sort of current abuse. The Dolan case makes clear that it's not a remedy to past abuse. And that was a case involving a child and a parent. But here, there was no evidence presented that the abuse here might resume if the abuse prevention order was not issued.
But didn't the plaintiff testify that there had been both past physical abuse, the dragging on the stairs, and also past sexual abuse, that the defendant had sexually abused her and physically abused her in the past?
She alleged that in her affidavit, and there was one question on direct from her attorney that was a leading question where she answered yes.
Okay. So under those circumstances, isn't the question whether there is a need for protection from the effects of that past abuse?
Yes. However, here, there was no demonstrated need for that. The last contact between these parties was also a response to something initiated by the plaintiff. It was a call and a a Facebook message and a text message following up on an affidavit that had been filed in his divorce by the plaintiff.
Which was still an ongoing litigation, am I understanding that correctly, at the time that the hearing on the restraining order, or the abuse prevention order was held?
No,
Was it
no,
over?
it had been concluded.
You had mentioned the Dolan case. This might be a little bit unfair to bring this up, but just a couple of weeks ago, there was a case that this court issued an opinion in Vanna V. versus Tanner T. You wouldn't have had a chance to cite it in your briefs, but in that case, this court noted the limited applicability of Dolan, I think for the reasons that Justice Hand was referring to, that judges should be taking into account abuse, even if it was many years earlier, that the language in the Dolan case that refers to sort of the here and now, that's really been taken out of context over the years, that it's the entirety of the relationship that is really something that judges should be considering. Would you agree with that?
Yes, but I think it also depends on the severity of the abuse. And here, there was no abuse that was particularly egregious. It was, and not to say that it wasn't, that she didn't consider it abuse or that,
Are
you
you
know, that's
referring
not
to
a fact
the,
that-
are you referring to the abuse that is detailed in the affidavit?
correct, from 10 years prior.
All right. Are you saying that it's not egregious because of the passage of time, or at the time it happened that it was not? Did I hear you say it wasn't severe? Is that what I heard you say?
Well, she didn't testify to any physical injuries or any, aside from the therapy that she ultimately led her.
Well, maybe we should leave aside the fact that, assuming that her affidavit is credited fully by the judge, which it appears it was, there was, as Justice Hans pointed out, an allegation that she was dragged downstairs. So I don't.
Yeah, and there was no further testimony on that as to was she pulled and, you know, led down the stairs, or was it, you know, dragged forcibly down the stairs?
But wasn't there an allegation of forced sexual contact?
There was.
Well, that's
and
pretty serious, isn't it?
that's an allegation, but there was no further testimony on that issue.
Well,
Other
I mean,
than
do you need further testimony?
I believe there should have been some additional evidence other than a statement, you know, a one-line statement on an affidavit as to the time
She
and
could have been
circumstance.
questioned about that. She was there and testified in court, right?
Yes.
Okay, and there were no questions about that posed?
Correct. Except from her counsel. You're correct.
Well, I mean, the opportunity to cross-examine was there.
Yep, agreed.
I just want to clarify one thing about the record, and that is that the fact that the plaintiff in this case had filed an affidavit in connection with divorce proceedings, and those proceedings had concluded, there was still ongoing proceedings that were connected to, in a way, and I put that way, to your client, right?
So that was alleged, or, you know, I assume reported to police by the plaintiff here. However, the defendant, you know, was never contacted for any of these. No charges have been filed. There's no litigation. And the fact that...
Well, we need to confine ourselves to the time when this order was issued.
Mm-hmm.
Right.
But the fact that this was a preventative measure, I think exceeds the bounds of the intent of the statute. It's for someone currently suffering from abuse, not someone potentially expecting some further abuse. And just based on the past history of her contact, or the defendant's contact with her, he stopped contacting her when she asked him to, and it was 2 attempts to contact her. So, you know, the earlier contacts after their relationship ended in 2009, the plaintiff alleged that, you know, there was frequent texting and calls and endless. She had to shut her phone off. But she sought no relief through the court at that time. You know,
I'm not so sure that's an argument you want to make, given the case law with respect to that.
But the most recent contact within the last 2 years did not demonstrate any dangerous contact or any threatening contact. It was seemingly innocuous, you know, based on her testimony in her affidavit.
Well,
So the final point I'll make is that this abuse prevention order was necessitated based on the plaintiff's own actions here. Defendant initiated no contact and hadn't initiated contact in over 2 years. And as discussed, the the prior contact was in reaction or based on the plaintiff's action at that time. So,
Well, you're not implying that the plaintiff is not entitled to make decisions and
no,
perhaps do things like file notarized statements, et cetera, which
not at all.
Presume he's telling the truth. All right.
Not at all. But there should be.
But you did say that your client's behavior was in reaction to. So I want to just be clear about that.
But so in the 2 years since that, though, there had been no action by the defendant, and it seems outside the bounds of the statute that a defendant who's done nothing in 2 years should be the subject of an abuse prevention order based on these facts. Mm-hmm. And I believe that's the that's really the crux of the argument. Are there further questions?
No, I think we understand your position. Thank you very much.
Thank you.
May it please the Court. Stephanie Holt for the plaintiff appellee in this matter. The standard for overturning the decision of the Dudley District Court is an error of law or abuse of discretion. I plan to address both of those standards. The language of 209A makes it clear a judge must consider as a factor the length of time since the relationship between the parties dissolved when there was no marriage relationship involved. The plaintiff wrote in her affidavit and testified concerning the type of relationship, frequency of interaction between the parties, how long the relationship lasted, and when that relationship ended. And while parts of what the plaintiff said concerning the relationship may have been contested after the ex parte stage, two things were never contested. One, the length of time that the relationship lasted, and two, the amount of time that passed after the relationship ended. The length of time since the relationship ended is something that needs to be taken into account at the ex parte stage to determine whether or not someone is properly applying for relief under 209A. It's important to note that the judge at the ex parte stage was not the same judge as the judge at the 10-day stage in this case. If the defendant agreed about the length of time that had passed since the relationship ended, then the length of time that since the relationship had ended, but where both parties are in agreement about when a relationship has ended, a 10-day judge could properly rely on the finding at the ex parte stage that a plaintiff is properly seeking relief under 209A.
Without disputing that point, does it make a difference if the judge affirmatively indicates that he or she does not need to consider that factor?
I would argue that it does not make a difference. 209A Section 4 states specifically that in the event, say, an ex parte is issued, a defendant does not show up, these matters, the order is to continue without any testimony from the parties. That's stated in Section 4 of 209A. What that means is that if someone does not qualify, they should never be issued an ex parte order. What the judge here said was not directly that that the length of time didn't matter. They said it was another issue. Given the timing that this occurred during the hearing after the plaintiff had testified, been cross-examined, and we were in closing arguments, it would make sense that this would be another issue at this point. If the plaintiff had improperly sought relief under 209A, then at the ex parte stage, the judge should have said, you do not qualify. Either at that point, the plaintiff could have qualified, could have applied under a different statute, or could have simply left the courthouse. So what we're trying, my position is that Judge Abdella did not fail in their duties to properly assess whether or not the plaintiff, who was pro se at the ex parte hearing, actually qualified under 209A. Now, if we had a situation where judges were not assessing at the ex parte stage whether or not the length of time since the relationship ended mattered, then there would be no need for an ex parte hearing of any kind. You just go ahead and issue them out to anyone who claims that they've been abused. Say someone has a neighbor who has punched them in the face. Well, why not give them the ex parte? They may be in imminent fear of serious physical harm from that neighbor, correct? But they would never qualify under 209A as simply a neighbor. That's why we have judges at the ex parte stage actually evaluate these claims. Otherwise, they should just go through the police department, and I think we would be done.
But doesn't the judge at the extension hearing have an obligation to apply the legislative criteria?
Absolutely, and I think that the judge at the 10-day stage should be able to rely on the judge from the ex parte stage's determination as to qualification for 209A.
He shouldn't, or she shouldn't independently make that determination?
I would say that that judge does not need to make a determination on that unless, again, the facts are in any way contested as to when that relationship ended. So what I'm saying is that if perhaps defendant contested, like, this relationship wasn't this long, this relationship...
But it was contested here, though. I mean, counsel did point it out to the judge. Judge, you have to take into account the length of time since the termination of the relationship and so forth. And he just, oh, no, I don't have, I don't have to get into all that. This is a substantive dating relationship. He just kind of jumped right to that conclusion without sort of taking into account what counsel was trying to tell him.
I hear that, but counsel did not state that it had been a longer or shorter time since the relationship ended. So Judge DeCapua at the 10-day stage could properly have believed that Judge Abdella had already found that there was indeed a substantive dating relationship, rather than reassessing. Or
You're saying just based on the fact that another judge had already made that determination?
correct.
I see.
So, and again, there just was no testimony, questioning, or statements to counter the fact that the relationship did in 2009, but Judge Abdella did go through, during the ex parte hearing, the plaintiff's affidavit, heard testimony from the plaintiff that the relationship had ended years ago, and then plaintiff gave specific testimony stating that when she ended the relationship, defendant threatened to rip the necklace he gave her from her neck and choke her with it, an incident that is clearly laid out in the affidavit as happening in June of 2009. I would say this is like a stark contrast to CO versus MM, where the judge improperly looked at judicially constructed factors rather than at those set forth by the legislature. We know that Judge Abdella did indeed look at the length of time since the relationship ended, the nature of the relationship, and the length of the relationship. Post-2009, there was continued contact. I would argue that those were all initiated by the defendant in this matter. When we're looking at that subsequent contact, we need to look at the totality of the circumstances of the parties' relationship. Here, a judge could reasonably conclude that the plaintiff was in fear of imminent serious physical harm given the history of abuse between the plaintiff and the defendant during the relationship. Defendant had threatened to choke the plaintiff in the past and had allegedly dragged her down the stairs, 3 flights of stairs. Given the history of the relationship, it would be logical for the plaintiff to fear that the defendant's hostility towards her never subsided and that she was in danger after reporting the defendant's abuse of her to police as well as other alleged crimes defendant disclosed to the plaintiff during the relationship. Again, any direct contact between the plaintiffs after they broke up, according to the plaintiff's testimony, was from the defendant making or attempting to make contact with plaintiff, stood behind her in a church service, and attempted to contact her through social media and text messaging, at which point she blocked him. So I hear that it's a message on text and a message on Facebook, which occurred less than 2 hours apart, which seems very quick. But given the history of the relationship that was testified to concerning the defendant in the past having called her incessantly for hours on end to try to get in contact with her, and then the fact that she blocked him, we don't know, and the plaintiff doesn't know, how much he may or may not have attempted to contact her.
But the obsessive calls and texts, those were back 2009 to 2011, right?
Yes.
And then 2012 is Facebook contact.
Mm-hmm.
Then an unknown time, the church appearance.
Yes.
And then 2018, he searched his wife's location, so that really didn't have anything to do with...
Not, yeah.
Okay, and then 2020, Facebook contact, and that's after she made that court filing.
Yes.
Now, that in and of itself doesn't suggest he's looking to do any physical harm to her, right? I mean, he's involved in some kind of litigation with his wife, and then a witness, the plaintiff, comes forward with some information, presumably to help the wife. He as a litigant, he reaches out to her. That's nothing improper about that. There's no evidence of a court order saying he can't, reach out to her, right? So where is there evidence here? Oh, and then the 2022 is she makes the report to the police department about his prior confession. So where in all of that is some recent event that would cause the plaintiff to have apprehension of imminent physical harm?
Sure.
it's going to befall her if she doesn't get this relief from the court?
To that, I would say that if we looked at this contact in 2020 in a vacuum, if we just took out the rest of the relationship and looked at it in a vacuum, it would not be threatening. The problem is that history, and that past history is incredibly egregious. I would look at Callahan v. Callahan. Abuse occasioned by physical harm can cause wounds that produce long-lasting fear in the victim without new incitements. I would say this is analogous, even though obviously this person is not in prison. The defendant in this matter is not in prison, so it is different in that way. But a plaintiff could still have fear years and years after what she detailed as far as physical abuse, sexual abuse, and threats to choke her, which I do not want to diminish, is a threat to murder someone. So it would be reasonable to continue to have that fear, and to have fear knowing that the last time the defendant attempted to get in contact with her was because she had involved herself in a form of litigation that did involve the defendant, and now she's reported to police. Reporting to police is potentially involving herself in another case involving the defendant, which again is going to increase that likelihood of subsequent contact from the defendant and put her in fear of imminent harm.
Now, what do you say to this language? And I took a quick look. I don't think it's been cited, but Larkin versus Air District Court, this is a 1997 case. The Supreme Judicial Court said apprehension over future lawsuit in court proceedings is insufficient to justify a 209A order. Doesn't that seem to be what's going on here? A plaintiff has an apprehension over what might happen as a result of her participation in the court proceedings or going to the police. And the SJC is telling us that that's not sufficient to get a 209A order. What do you say to that?
I would say that this is greater than a generalized apprehension, given the nature of the violence that occurred. Dragging somebody down 3 flights of stairs, each one of that during the course of a relationship is an incredibly violent act in and of itself. Forcing someone to engage in sexual relations, again, an incredibly violent act that could cause her to have fear, reasonable fear, objectively reasonable fear, for years and years to come. Further, it's understandable that one would continue, that although a piece of the fear is going to come from reporting to police, that fear is knowing that history of attempting contact after any kind of litigation happens, knowing that it's likely that the defendant is going to reach out to her again. And the defendant did have her social media account of Facebook, had her phone number, even though blocked on both. At some point, it becomes a question of how much does the plaintiff need to do to protect herself from this person. The last thing I want to say here is that the standard for review is an abuse of discretion or other error of law. There was not an error of law here. Ex parte orders could be issued as a matter of course, again, without the need for an involvement of a judge if we weren't going to take into account those ex parte judges and their findings. And as stated in LL v. Commonwealth, an abuse of discretion exists where a judge made a clear error of judgment in weighing the factors reasonable to the decision, such that the decision falls outside of the reasonable range of alternatives. So I would ask this court to consider what is a reasonable alternative for someone who does not contest forcing someone to engage their partner in sexual relations. What is a reasonable alternative for someone who drags their partner down 3 flights of stairs? What is a reasonable alternative for threatening to choke someone for ending a relationship, if not an order of protection? What amount of time would make that behavior feel acceptable and non-threatening? And for all other issues, we rest on our brief if there are no further questions.
See no further questions. Thank you both very much. All right, that concludes our arguments for today. I want to thank everybody for participating in the courtroom, and the court stands in recess.